This video is part of a series of videos that deal with legislation and service delivery. Two of the videos deal with service delivery for adults, and this video deals with legislation and service delivery for children. It's important to begin with legislation because the legislation lays the groundwork for the services that are provided within the schools. And so that's where we're going to begin. We'll be going back and forth, starting with early legislation, talking about how that has evolved, and we'll be gradually building up to the present time frame. And then at the end of this presentation, I'm going to talk about the service delivery models that have sprung really from this early legislation. I've mentioned this before, but my background is both with children and adults, working in the school systems as an itinerant O&M specialist, and working in adult service agencies, also as an O&M specialist. Let's begin. The legislation that we're going to talk about lays the foundation for the services that really have led to the models. And so we'll begin by looking first at some of the legislation, how it's unfolded. And this will be a graduate trip looking at the early legislation, moving on to today's legislation, looking possibly at future legislation, and then we'll cover the models of service that are based upon the legislation. One of the earliest pieces that I want to talk about is the 1954 Cooperative Research Program. This is one of the early pieces on the long path leading to the current legislation. This authorized cooperative research and education between the government and institutions of higher education. However, about 2/3 of the funding from this particular piece of legislation was earmarked for the area which was called mental retardation. That's the term that was used at that time. Of course, now we use the term cognitive impairment, intellectual impairment, but at the time, mental retardation was the term that was used. In 1958, we saw an act called Training of Professional Personnel, and it provided $1 million to colleges and universities to train professional educators. Again, however, the money from this grant was used for teaching students with cognitive impairments. Blindness didn't figure into the picture yet at this point in time. In the 1960s, there were concerns raised about the type of classroom students types of classrooms that students should be in and how long they should be in those classrooms. Should they be in special classrooms? Should they be in with regular ed students, etc.? What kinds of services should they receive? And there were concerns that many students were excluded from receiving special education services. At that time, Judy Heumann, who was secretary, was an advocate for making sure that students receive special education services and that they be included in regular education classes, as well as residential schools. So at that time, the local school boards and the principals were making decisions about attendance of children with disabilities and where they should be placed. In 1966, we had amendments to the Civil Rights Act of 1964, and these amendments established the Bureau of Education for the Handicapped, and the purpose was to provide leadership in special education. We don't use the term handicapped any longer. It's interesting, the derivative of that word basically comes from beggars who would take their hand, place a cap in their hand, and would ask for money. And so certainly we don't want to use that term any longer, but that was the term that was used for quite a while, until more recently when it's been changed. In 1968, we had Handicapped Children's Early Education Program, and it funded model demonstration projects. These were projects for delivering experimental education programs to young children who had disabilities. In 1970, we saw the Education of the Handicapped Act, and it provided grants in various stages to encourage educational programming for students with disabilities. There were a number of court cases that greatly influenced services. One was the Pennsylvania Association for Retarded Children versus the Commonwealth in '71, and another was the Mills versus Board of Education of the District of Columbia in '72. And both of these cases established responsibility of the states and the local school districts to provide education of students with disabilities under the Protection Clause of the 14th Amendment of the Constitution. Now, the 14th Amendment, the principal purpose of this amendment was to make the former slaves become citizens of both the U.S. and the state in which they lived. And the amendment forbid the states to deny equal rights to any person. But this amendment has been used for the rights of students with disabilities as well. The phrase due process of law really has been ruled to forbid the states from violating most rights protected by the Bill of Rights, and education certainly is a right that we need to protect. So intellectually impaired students who had been denied the right to various services were the object of these court cases, and it was determined that they had the right to receive services, to receive education. In 1975, we saw the granddaddy of our current legislation spring into existence. It's the Education of All Handicapped Children's Act, PL 94-142, so commonly used that it just easily comes off the tongue. And it basically led the way for so much of what we do today. It required that a free and appropriate public education, FAPE, free and appropriate public education, known as FAPE, be provided for all children with disabilities in the U.S. Now, children up to the age of 5 might be excluded from that education in some states at that time. That's not the case any longer, but at that point in time, that had not yet evolved. However, the law did provide non-discriminatory education. It provided procedural due process. It provided an individual education program where the IEP comes from, and it provided education in the least restrictive environment, LRE. That's where it comes from. 1975 Education of All Handicapped Children Act. In 1986, we saw the Education of the Handicapped Act amendments. It extended a free and appropriate education to all children with disabilities ages 3 to 5. So now we begin dipping down a little lower in terms of providing education for younger children. It established also the Individualized Family Service Plan, the IFSP, the teachers, TVIs now are responsible for. In 1986, the Handicapped Children's Protection Act provided parents with a new weapon. Parents who prevail in administrative hearings or court actions could have their attorney's fees and expenses reimbursed. Up until this point in time, that wasn't a given, and with this legislation, it led parents to have the ability to challenge decisions that were made in the school system. In the early 1990s, we saw the development of the major piece of legislation, the Individuals with Disabilities Education Act, or IDEA. Between 1990 and 1991, this evolved, and it renamed the Education Handicapped Act to become IDEA. It added 2 new categories, autism and traumatic brain injury. So IDEA came from this. It required an individual transition plan, an ITP, to be developed no later than age 16 as a component of the IEP process. It also included rehabilitation and social work as related services, and added definitions of assistive technology devices and assistive technology services, very important components for services for children with disabilities. Part H was added in 1991, and Part C and its components were also added at that time. And Part C is often referred to as baby IDEA because it really went even further down below 3 and provided services for infants and toddlers. A very important service because we know if we start early enough, we're much more likely to have an impact than if we start later. So, assistance was provided to any state that wished within 5 years to develop a comprehensive system of early intervention services for infants and toddlers. Very important. 1997 saw the reauthorization of the Individuals with Disabilities Education Act, or IDEA. It did many things. It strengthened the mediation process. It provided for alternative placements of students. It basically advocated for functional assessments and for manifestation determinations for students who might be suspended or expelled for violations of school behavior codes, especially when that behavior might be related to their disability. It encouraged the provision of educational services in the least restrictive environment wherever possible, but it also retained the support for a provision of services along a continuum of services. So in other words, it recognized that not everyone needed to be in public schools. Many students would see their least restrictive environment being in specialized schools. And another thing that it did, a landmark decision, it enabled O&M to become a related service. And so now, when related services are considered in the IEP, O&M is one that really needs to be on the table. All right. A further and most recent reauthorization occurred in 2004 when President Bush signed the long-awaited Individuals with Disabilities Education Improvement Act. And that reauthorized IDEA. And the primary purpose of IDEA remained unchanged: to guarantee a free and appropriate public education to every child with a disability. Changes occurred as a result of the 2004 reauthorization. Let me talk about a few of those. Some of the definitions were clarified. Tourette's syndrome, for example, was added. Discussion was made and definitions were changed regarding the preparation of teachers in charter schools. They must meet the same standards as those in public schools. They changed certain terms. Biological, they substituted for natural parent the term biological parent. They also came up with a regulation regarding students who have surgically implanted devices, saying that they're still able to receive special education services, even though those devices help ameliorate their disability. And the definition of orientation and mobility service was changed, and it was removed from the term travel training instruction. Up until this point in time, O&M, orientation and mobility, was kind of matched alongside the term travel training instruction. And travel training instruction is teaching students with disabilities other than blindness to travel. And it is not a profession that is well developed at this point in time, and there was much confusion. And so the term travel training instruction is in the definition of special education, and orientation mobility is defined as a related service, separate from travel training instruction. FAPE was discussed. In Section 300-101C, he said that that section was revised to clarify that a free, appropriate public education, or FAPE, must be available to any individual child with a disability who needs special education and related service, even though the child has not failed or has been, retained in a course and is advancing from grade to grade. So in other words, continuing on in special education even though you're successful. It discussed the LRE as well regarding placements. It was revised to remove the term, quote, unless the parent agrees otherwise, unquote, from the statement that says that a child's placement must be as close as possible to the child's home and that the child is educated in the school he or she would attend if not disabled. So in other words, it gave greater leeway to where the child would be placed. It also changed to clarify that each public agency must ensure that each child with a disability has the supplementary aids and services determined by the child's individualized education program or plan, IEP, to be appropriate and necessary for the child to participate with non-disabled children in the extracurricular activities and activities to the maximum extent appropriate to the needs of that child. So it really broadened services. In regard to parental approval, parents have the right to refuse an evaluation of their child, but the department must make every attempt possible to gain that permission. So giving a little more authority to the department. In regard to evaluation guidelines, procedural safeguards, model forms were developed for procedural due process complaints so that it would be easier for parents to form those complaints. And then finally, disciplinary regulations, guidelines were developed regarding removal of a child from a placement so that it was understood that a child who has a behavioral problem because of this disability should not be removed necessarily, or that the behavior needs to be improved rather than removal of the child where possible. Way back in 1965, there was the ESEA Act, the Elementary and Secondary Education Act. It was signed into law by President Johnson, and it offered grants to school districts that served low-income students. That was later followed by a law called the NCLB, or the No Child Left Behind Act. And that law had good intentions, but it had prescriptive requirements that became unworkable for many schools. And it has been replaced by more realistic standards that are more state-driven. And as a matter of fact, kiddingly, many people would refer to the No Child Left Behind Act as the No Child's Behind Left Act, because it emphasized testing above all else and didn't take the child into consideration as much as it did the testing. And instead, the older act, the Elementary and Secondary Education Act, had more of an emphasis on local assessments rather than national assessments that were maybe more appropriate. Well, along comes modern times, and we come up with something that's called the Every Student Succeeds Act, or the ESSA. And that was signed into law by President Obama in 2015. And it reauthorizes the Elementary and Secondary Education Act. And it's the nation's education law, and it's its nation's commitment to equal opportunity for all students, and it replaces the No Child Left Behind Act. So what is the future? Although IDEA is scheduled to be, or was scheduled to be reauthorized in 2011, the reauthorization of that act has not yet happened. And so professionals have kind of come together and they've supported a supplementary piece of legislation, and it's called the Cogswell-Macy Act, and the purpose of it is to strengthen current services. And there are certain things that it is intended to do. It's intended to guarantee the inclusion of the expanded core curriculum, or the ECC, in all schools. That's something we're going to talk about very soon. It also is intended to strengthen the training of teachers, and that services need to be provided by trained teachers. It says that there must be better data collection on students who are blind and have other disabilities, because often when there is more than one disability, the blindness may not be a reported disability or a primary disability. There's a requirement for the monitoring of states' compliance with the laws, and there's a call for a national resource center to foster research on teaching students. So these are things I think we will see in the future, especially if this act comes into being. All right, we've talked about the expanded core curriculum, the ECC. And what is the ECC? I was present at a meeting at the American Foundation for the Blind when this was first discussed. And it was very clear that students often weren't receiving Braille. It was a secondary service that was sometimes provided, but not always. And they also often didn't have O&M. They didn't have independent living skills or many other skills that they needed. And so from that meeting sprang kind of a national agenda called the ECC. And it included skills that needed to be a part of every blind child's curriculum. And today we find that TVIs often must do an assessment of the ECC to make sure in their school that their students are receiving the skills that are required. So they include such things as academic compensatory skills. That also means that Braille, it's presumed that a child needs Braille, unless proven otherwise, instead of the other way around. Career education, independent living skills, orientation and mobility is a part of this. Recreation and leisure, self-determination, often relating to advocacy, self-advocacy skills, social interaction skills, use of technology, and the use of training of vision, visual efficiency skills, all a part of the ECC. So what are some of the current issues that are facing IDEA as we move ahead? Well, due to some of the conflicting decisions from the circuit court level, some of the following are under consideration. Parental revocation of consent for special education services, representation by non-attorneys at IEP meetings, allocation of federal funding, due process for parents and students, individual education programs, revision of the components, the discipline issue again, we've talked about earlier, and teacher quality and effectiveness, determination of teacher quality. Those are all things that probably will be on the docket. So let me talk a little bit more about some of the enabling legislation. We've talked already about orientation and mobility as a related service. Since 1994, orientation and mobility has been included in IDEA as a related service in the same category as physical, occupational, and speech and language therapists. Related services are mandated to be required for students so that they can receive the maximum benefit for their special education. Its inclusion provides emphasis to parents and special education administrators for the need to incorporate O&M decisions into the IEP process. So very important to be a related service. It's always on the mind of those who are conducting the IEP program evaluations. Now, we've talked before about the No Child Left Behind legislation. It had within it the highly qualified designation. It said that it required the states to utilize professionals who meet the state's credentialing and licensure requirements. That highly qualified teachers are considered to be competent in both academic content areas as well as in teaching strategies. Highly qualified teachers now has become a defined topic in the Elementary and Secondary Education Act. So it is still there. And it is something that we need to continue to insist upon. let's talk about student eligibility for orientation and mobility instruction. It's a decision that is a multidisciplinary team decision. IDEA mandates orientation and mobility when it's a required related service in a student's program. So it has to be discussed as a possible related service. And this determination is made by a multidisciplinary team after a comprehensive assessment and development by the IEP process. One of the videos that you're going to be looking at is the Orientation and Mobility Functional Assessment. This is a very important assessment that is part of the related service determination. So typically the IEP outlines the annual goals for the student, the general education classes, the special education classes that are required, and the related services that the LEE is required to provide or the specialized school is required to provide. So typically, school-aged children, students, qualify for O&M when it's documented that their visual impairment interferes with their ability to develop environmental, spatial, or body concepts, and to travel safely, efficiently, and independently in the home, in the school, or the community environment. Sometimes the schools like not to deal with the community environment, but that is a part of the law. So what are the service delivery options? They spring from the LRE and from its meaning of the least restrictive environment. Special education services are mandated by federal law to be provided in the least restrictive environment. That is a setting as near as possible to the student's home and with other students who do not have disabilities. The regulations to the law provide for, however, a continuum of alternative placements. These include specialized schools that have residential and day components, as well as local education agencies, LEAs, such as general education, teacher consultant programs, resource rooms, self-contained classrooms, and itinerant programs. And orientation and mobility can be delivered in any of these placements. But let's talk about LRE and let's talk about full inclusion. In the latter part of the 1980s, a great deal of emphasis was placed on providing a full inclusion experience for students with disabilities in a general education setting in their local communities. This, however, is not a federal or a state law, but instead is a philosophical perspective. Where it exists, the goal is to have an appropriate support system within whatever setting is chosen, including orientation and mobility for the students who need it. However, some schools seem to object to having students in their general setting being pulled out for orientation and mobility. And that's because they are afraid that it will remove them from being exposed to the higher academic skills and ultimately could even endanger the school's standardized test scores. However, as orientation and mobility instructors, we need to be advocates, as well as teachers need to be advocates, for students to be pulled out of classes in those settings, or to have a special class in those settings, so that students can have orientation and mobility. Sometimes sharing a copy of the National Agenda for Children and Youths with visual impairments can be helpful, or just talking about the expanded core curriculum as one of the means for acquainting the districts with the need for these related services. Now, the models themselves, the setting for the services. Specialized schools for visually impaired students are either state-operated or private-operated schools, and there are both, that provide a regular school curricula as well as special instruction in the blindness-specific areas. The services are offered on a day basis, where students come in for the day or for part of the day, or on a residential basis where students stay in the school and live at that school, or even outreach services to the local area schools, along with assessment services and technology training and professional development for teachers. In recent years, these schools have had a large increase in multiply impaired students. These schools are also known as residential schools for the blind. It used to be back years ago that most of the students who were visually impaired would go to these specialized schools, and that the numbers were very large. Today the numbers are much smaller, and the majority of the students have multiple impairments. However, previously it was made up of a more variable population. There are a lot of advantages to these specialized schools. They really know the curricula for blind children. They have teachers that are very proficient in Braille, that know the assistive technology, that know adaptive PE, that provide all of the experience of the ECC for their students. And so they're a good, strong experience. But at the same time, the students that go to those schools don't have the same experience with their sighted peers. So there's always been this tension between the specialized schools and the local education agencies. Now, the local education agencies, or the local or county or regional school districts, they're the ones that receive their financial support through local taxes and the state funds. And they provide both general education and special education services. While most of these districts employ their own special education teachers and sometimes even their own related service providers like O&M specialists, others have turned to regional programs. For example, some are known as BOCES, Boards of Cooperative Educational Programs. We see that in New York and in Colorado. Or CESA, CESA, Cooperative Education Services Agencies. And now, increasingly, we're seeing that these local education agencies are contracting with private firms that provide services. And I would caution that if you are an O&M specialist working with one of these private firms, that you receive an appropriate payment for your services, which typically in this day and age is about $70 an hour. Sometimes it's a little less, sometimes it's between $50 and $70. But certainly don't be taken advantage of and settle for less funding than that. With the amount of education that you've received and the time that you've put into preparing for this profession, you really should be remunerated appropriately. Now, the local education agencies certainly have a lot of advantages as well, and especially in orientation and mobility. The use of actual routes that the students will be traveling is possible because the instruction is provided at their school in their home environments. So there's no difficulty in generalizing from a training area to one's own home environment. But there are some disadvantages as well. Some of them have to do with the instructors have to drive distances between schools. That takes away from the time they could be spending with students. The instructors have to carry equipment along with them on each visit. And the students are learning their own areas, but may not have the confidence to generalize it to other areas. Let me also mention that some of the other models are in play. There are consultants that come in. There are resource rooms in larger cities where students with disabilities will come together in that room, and we'll have teachers there who will work with them. And there are even self-contained classrooms in larger cities where there are large numbers of students who actually can make up a classroom. So those are all of the settings that are possible, and they spring from the legislation that we have been talking about.